Hi, my name is Dana Cornwall, and I'm Project Manager at the National Self-Represented Litigants Project. If you're going through a legal dispute, it is never too early to think about settlement. More than 95% of family and civil cases settle before a final trial. Often this happens right before trial, after an enormous amount of time and effort has already been spent. This is why we suggest you get settlement smart sooner rather than later, and that as your case evolves, you remain open to the possibility of settlement. In this video, I'm going to share some tips for getting into a settlement mindset, give you an overview of different settlement processes you might encounter, provide strategies for navigating these processes, and leave you with some important final takeaways. I encourage you to also check out our other settlement resources, especially the print guide, Settlement Smarts, available on our website, representingyourselfcanada.com. Remember, almost every case is eventually going to settle, and it's likely yours will too. If you settle, you have more control over the outcome, and you'll relieve stress and frustration. Be smart about considering settlement options early. If you settle, you won't get everything you wanted, but you may get enough to make it worthwhile, and you'll avoid a long battle with no certainty of things going your way in the end. Even if you don't settle early in your legal matter, keep considering the possibility. Settlement can happen at any time. Keep in mind that making an offer to settle is not an admission of fault, nor is it a sign of weakness. Rather, it's an attempt to settle a dispute in a way that is fair, practical, and reasonable. There are 3 types of settlement processes you may encounter: negotiation, mediation, and judge-led settlement processes. Negotiation takes place between you and the other side away from the courthouse. You work directly with the other party or with the lawyer on the other side, and no mediator or judge is involved. The goal is for you and the other party to reach an agreement. A successful agreement can be brought to court and turned into a consent order. In mediation, you may work with a private mediator outside the courthouse, or a mediator appointed by the court who works in a court-based program. The mediator is a neutral third party, not a judge, and they may or may not be legally trained. The mediator helps you and the other party explore how to reach an agreement. A successful agreement can be brought to court and turned into a consent order. There are several different types of judge-led settlement processes: case management conferences, trial management conferences, settlement conferences, family conferences, and judicial dispute resolution, or JDR. Judge-led settlement processes happen in the courthouse and are led by a judge who will be excluded from hearing your case if you end up going to trial. In case and trial management conferences, the goals are to gauge how likely settlement is and to set a timetable to get you into a position where you are ready to negotiate. In settlement and family conferences and judicial dispute resolution, the goal is to bring parties closer to an agreement, which the judge may help you draft. For much more information on judge-led settlement processes, see our print primer, Settlement Smarts. If you have an understanding of different settlement processes, there are lots of things you can do to make sure your process is effective. There are 2 types of settlement negotiations: informal negotiations and formal offers to settle. Informal negotiations take place between you and the other side directly. You can use informal negotiations when an immediate issue needs to be resolved, or a temporary measure is needed, or when you believe the entire matter, including costs, can be solved. You can initiate informal negotiations by drafting and submitting a proposal to the other party, or by arranging a meeting to discuss settlement. Some tips and strategies for effective settlement negotiations: document all discussions. State that your proposal is without prejudice, which means that all discussions are informal and cannot be used at trial. And Be prepared for counter offers. For formal offers to settle, the rules of civil procedure in your province or territory must be followed, meaning that the relevant rule must be referenced for the offer to be official. You can make a formal offer to settle at any time after the lawsuit has begun. Some tips and strategies for formal offers to settle: state your intentions, don't pressure the other party unnecessarily, make an offer they will seriously consider how the court might rule if you were to go to court, and get a second opinion. Be aware that there are risks to refusing a formal offer to settle. If you refuse a reasonable offer and go to court, you may end up losing a lot more. And if you refuse a formal offer to settle and the judge later decides at trial that you should have accepted, they might even order you to pay the opposing party's legal costs. On the other hand, if you make a formal offer to settle and it is refused before you go to trial, the opposing party might be made to pay your additional costs if the offer you made was fair and the judge decides it should have been accepted. What is mediation and what is it not? Mediation is not a trial, but it is a face-to-face meeting with a mediator who is usually a trained professional with relevant experience and is not a judge. The mediator is an impartial third party who will help you work through challenging issues. Anything said or proposed in mediation is confidential. This means that if you later go to court, you can't repeat anything the other side said or proposed, although you can repeat things you said or proposed during mediation. There are exceptions to the general rule of confidentiality, so when you go into your mediation, it is best to ask the mediator if the process is open, things said can be used at a later trial, or closed, things said can't be used at a later trial. Mediation is a voluntary choice. The only exception to this is that some courts may require you to attend an initial mediation to explore settlement. Before mediation, you should prepare some concrete ideas on what type of deal you're willing to accept and think about what the other side may want. Prepare yourself to hear the other side make statements that you believe are unfair, inaccurate, or hurtful. This will allow you to anticipate what may happen and to stay calm so that you aren't thrown off. When you're sitting in face-to-face mediation, listen to what the other side says about what's important to them and why. Explain to the other side what's important to you and why, and make sure you both understand one another's specific concerns. And then proceed to discuss possible solutions. Some tips and strategies for mediation. Confirm with your mediator what documents you need to bring. You may also want to ask the mediator what documents, if any, the other side should bring. Avoid displays of anger, even if you feel you have good reason to be angry. If you need to discuss something in private with the mediator, or you need a short break, you can ask for a caucus. Make a list of what you want and why. Both sides need to understand each other's desires to reach an agreement. Before mediation, make note of your goals and what settlement terms you could live with. Prioritize your list. Rank your desired outcomes in order of priority and classify each outcome as either desired or essential. Identify what you could be more flexible on. To reach an agreement, both sides will need to compromise. Think about what you can and cannot be flexible about. Brainstorm alternatives to your essential items. Think of other ways you could achieve your essential outcomes. Remember, you only need to use these ideas if you decide you want to. Get another opinion as a reality check. Ask someone who knows your case well for their thoughts on your desired outcomes, bottom lines, and alternatives. Assess what may happen if you don't reach an agreement. Realistically assess your best alternative and worst alternative scenarios and prepare for each. What should you do if you reach an agreement during a settlement process? First, put the agreement in writing. Either you or the other side can draft the agreement. Next, review the agreement. Make sure you're truly comfortable with all the items. And finally, both you and the other side must sign the agreement. After it's signed, the agreement can be submitted to the court. To finish off, here are 8 important reminders to take away for settlement processes. 95% of civil and family cases settle, and likely so will yours. Do your best to come to a settlement instead of going to trial. You cannot be forced to make an agreement. You may not be thrilled with every aspect of the agreement, but your agreement must be voluntary. Stay in control of the process. It is your right to ask questions and take time to review. Get crystal clear on what can be enforced in court, for example, payment of money, distribution of assets, child custody, etc., and what cannot, for example, an apology. Always put agreements in writing. This will help to avoid future disputes over the content of the agreement. If possible, take time to decide. Before signing, give yourself time to think about all of the immediate and longer-term implications of the agreement. Get a second opinion about your settlement proposal from someone who knows what's important to you, or, if possible, a lawyer who can provide this service at an unbundled or hourly rate. Ultimately, settlement is your decision. Regardless of any advice you receive, remember that the final decision rests with you. I have covered only a portion of the information available in our print resource on Settlement Smarts. To find this and many other helpful guides, visit our website, representingyourselfcanada.com, or look for the link in the description of this video. Settlement Smarts, like all our resources, is free and downloadable.